Welcome back to the county seat. Our topic today has been indigent defense. We've been talking about some of the challenges, perceived, actual, or otherwise, that face the counties, particularly the rural counties, in providing good, adequate defense for indigent people. Part of the discussion, I think, really needs to be the constitutional side of this, because, you know, David said earlier, very much tongue-in-cheek, well, why do we need to spend money defending them? They're indigent, they're guilty. But there is a very serious core constitutional issue about which this country centers, about the right to be judged fairly by a jury of your peers under all circumstances. And I think that in the constitutional manifestation of that and the interpretation in Gideon versus Wainwright, we have established that if somebody can afford an attorney, that is a right that they have to help them prepare a case. So let's talk about those merits for just a minute and whether or not we're meeting those merits. You two obviously have a different point of view at both ends of the table.
My comment, we've talked about this in the past. Mr. Meehan and I were on the phone the other day, and I said, why is it the ACLU thinks we're not meeting those standards? And I understand that they have a reason for pushing an agenda. And I don't think that it's wrong in doing so. But the courts set a line of expectation, and I'm obligated and sworn an oath to uphold that. I'm concerned that the ACLU thinks for some reason it's their obligation to somehow either indicate that the line's gone down or we're not meeting it. If that's the case, I don't know why they think that's the situation in Utah, because we're trying to do, just as you've indicated, provides a service that's constitutionally required in each case where a defendant's been charged. And I guess, where's the problem?
Yeah, and my first comment would be that, you know, courts, what they do is they do set a line. They set a minimum of what needs to be met. And, you know, for the ACLU, we don't see that line as, you know, we see that as the floor. And our goal is to try to go above that floor. You know, we're committed to civil rights, and I think that everybody should be. And so, you know, Utah has the opportunity to go above, you know, what, you know, the federal courts say is, you know, the absolute minimum of what has to be provided. Why should we just stay there? You know, we should be more protective of people's rights.
But I think there's also evidence in the report that in some counties, not yours, you know, present company accepted, that there are counties that are struggling even to meet the floor. And I think that's where the Constitution comes into play, and that's where, you know, we all as citizens should become very concerned, right? I mean, there are certain countries in this world, we all know which ones they are, where if the government says you did something, that's it, right? You're going to jail or prison.
No, usually those have something to do with hands coming off.
That's right.
Things like that. I'm just saying.
Well, and that's not how we operate. You know, I think though that the way, you know, the way some counties have their system set up, it is almost inevitable that you're not going to be able to meet the floor, right? Where you have a complete failure to provide training, where you have a failure to provide access to experts and investigators, where there's underfunding, there's no supervision, there's no monitoring, there's no accountability, where the county doesn't even know, you know, how many cases their public defender has, much less whether the person has any conflicts of interest, right? That's creating an environment that is just ripe for you know, defendants not having their rights met. And I think that, you know, even in counties that are trying to do it right, you know, if you have systemic deficiencies built in, where either the county attorney is involved in the selection process, or you know, there's no tracking of caseloads, or there's no you know, caseload limits or guidelines on when you have to visit your client in jail, that it's almost inevitable that you know, you're not going to meet the floor in at least some instances.
Your county attorneys have addressed this when they've met with UAC and in other venues. You guys have talked about this, have you not?
We have. Professor Chang has been sending out students for the last couple of years, been asking through the law, through grammar requests, to confirm the process of which counties have been selecting, hiring, and paying public defenders. I welcome the idea that we're going to do it better. I mean, that's expected, I think, of everybody in the criminal system, to make sure defendants are provided adequate representation, that judges are prepared for hearings, and the prosecutors are getting it right.
Can you actually overcorrect it? I mean, that's a fair question because, I'm very serious about that because the counties are now working on a contract, and I haven't seen it. I wouldn't understand it really if I read it, and I have to get things in executive summary so that they sink in. But the counties are working on a contract, trying to address some of these issues, and yet it hasn't been widely distributed yet. It hasn't been encouraged to be implemented. Maybe that will solve most of the problems, and if you overcorrect something, quite often, as you'll see with many federal agencies, you create more of a problem in areas you don't expect when you try to overcorrect something. So I'm just tossing that idea out on the table.
Well, right now we would settle just for reaching the floor. I mean, I would not be concerned about overcorrecting. As I said, our role or our goal is to make sure that we're more protective of rights in general. I would not see, going over what the floor is, I wouldn't see that as a bad thing. And I don't think that we should see that as a bad thing.
I mean, I think you can think of it as, the Constitution doesn't entitle you to a Cadillac defense, right? You get maybe like a Pinto defense, right? Or a Chevy. But
okay, now you're talking in terms I can understand.
Is there a harm to, saying, okay, every defendant, you're going to get the O.J. Simpson defense team? I don't think that's a harm. It's not like anyone's going to.
But that's not what Gideon said.
No, exactly.
And I think
I fully agree.
But to suggest that at a state level, somebody in Salt Lake will decide what to do in St. George or Kanab or Moab is offensive to local
But I don't think that's what state involvement has to mean. I think, ideally the state would be a facilitator to enable the counties to do what the counties need to do. Well, right, so that the state, so for example, right, the prosecutors have a statewide association that provides and pays for yearly trainings for county attorneys. And that's something that the state could do with minimal involvement. It's not the state saying, okay, you need to do this or you need to do that. It's, we're going to make these trainings available to public defenders. It makes sense because why have 29 different trainings in 29 different counties, right? Or we're going to provide you with the software to check conflicts, right?
And I would also say that, you do need some independent sort of objective look at what the counties are doing, because you would imagine, every parent, they look at their kid and they think, well, he's an A student. Well, but then you're going to need the objective, independent person. Well, how are they comparing against the other students in the class? Similarly, how is Utah comparing against other states? How are we living up to these objective guidelines that, different organizations like, the National Association of Legal Defenders has put out, the ABA has put out. So, it would be, it sort of would improve the system to have an independent eye on this, and
And to address first the training issue, the county attorneys have pushed the Utah Prosecution Council to allow all of the legal defenders to attend our program. In fact, the state MCLE board requires for the training to be accredited, it has to be open to defense bar members. The counties are now paying for those public defenders to attend that same training. If it's good for the prosecutors, it's got to be good for the defense attorney to understand where we're coming from. Whether or not we're meeting the expectations of Montana and Colorado, I want to meet the expectations of our community first, and I'm not going to worry about the outside communities.
No, and that's fabulous that they can attend your trainings, but maybe they need defense attorney specific training, right? I mean, surely you could see that, right? I mean, that.
Sorry.
Anyway, we've run out of time here for this segment, and it's been a very good conversation. This could go on for hours. Thank you for joining us on our extended version of The County Seat. We'll look for you next week, Sunday mornings at 8 on ABC4. Thank you.